Good afternoon. Good afternoon. Welcome to our committee meeting day. And today is Monday, February 3rd, 2025. It's 2 p.m. and I'd like to call to order this meeting of the Tennessee State Board of Accountancy. Notice of the February committee meetings of the Tennessee State Board of Accountancy, including date, time, and location, has been properly noticed, and copies of the agenda were posted to the Board of Accountancy website on Monday, January 27th, 2025. Individuals who would wish to make a public comment on an item listed on the posted agenda during the scheduled comment period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. And I believe the sign-in sheet is on the back table. Is that correct, Karen? Thank you. The public comment period will take place at the end of this meeting. Today's meeting consists of the board's 4 committees and their various agenda items. The full board meeting will take place tomorrow, February 4th, beginning at 8:30 a.m. At this time, I would like to welcome our visitors and members of the public. I think we have 2 visitors, Kara Fitzgerald and Katie Cheek, both from the Tennessee Society of CPAs, and welcome to each of you. Jen or Karen, are there other visitors? Okay.
No, sir.
Very good. I would also like to take this time to formally welcome our new executive director, Jen Binkley. Jen has been on the job about 3 months now, but this is her first meeting to lead us today and tomorrow. And Jen, thank you. It's so good to have you on board. A lot has been going on over the last 3 months, and you'll hear more about that today and tomorrow. But Jen has been extremely busy, as has our entire staff. So thank you, Jen, and welcome aboard. I would also like to inform you that one of our board members, Mike Parton, I should say, a former board member, because Mike has resigned from the board. He was in a situation where he felt like there was a potential conflict of interest, and so Mike attended our October meeting, but shortly thereafter he resigned from the board. So in accordance with our statute, the TSCPA will be providing a candidate name or names to fill the slot that Mike has vacated. But sorry to lose Mike. Mike is a great individual. I hope you got to meet him if you didn't already know him, but he will be missed on the board. Also today and tomorrow we will be without David Crenshaw. David had a unforeseen conflict arise, and so he is unable to attend today's or tomorrow's meeting. So we will again be without David for these 2 days. As I mentioned earlier, a lot has transpired since our last meeting, and we will get into that in a great bit of detail shortly. I would like to also mention, and I got Pam's permission to do this, but Pam lost her mother recently, and so I offered our condolences to Pam. And your mother was one of many accountants in your family, and so I know that you will miss her greatly. But the good thing is good news is she was in her 90s when she passed away. But
a month short of 98,
good.
And lived by herself independently. But I sure miss her.
So. Yeah, that's wonderful that she had that long life, and but we offer our condolences to
Thank
you. And lastly, I will mention to the board members specifically, be sure and turn on your microphones as you speak. Our system allows for 4 mics to be on at a time, and often we exceed that inadvertently. So try to make sure your mic is on when you're speaking and off when you're not speaking. And at this time, I will turn the meeting over to our licensing committee chair, Dr. Pam Church.
Thank you. We have several items that we are to consider. We have 2 requests for extensions. We'll do those last, and let me do the others first. The initial one is a request to grant business course credit for a Belmont entrepreneurial course. And what happened was that a student in the Masters of Accounting there applied to take the CPA exam, and they denied the credit for this to count as a business course. Not an accounting course, but a business course. And a professor noted that they've offered this as an elective for many years in the MAC program, and this is the first time that NASBA had not counted it. And I assume it's because entrepreneurship is not one of the specific topics that counts as business, that some of you may recall that a while ago we came up with a list of what is business. And if I could just get to that, I'll read it to you. Thank you. All right, so it's algebra, calculus, statistics, probability, business communication, business law, economics, ethics, finance, management, technology/information systems, marketing, data analytics, and related one, and then other business-related content areas included in the uniform CPA exam blueprints, or as may be approved by the board. I would argue that entrepreneurship is really by definition business, because you are teaching business topics just in a certain context. That's my bias. And both at Rhodes and now in my role at Christian Brothers, I have said that when we teach entrepreneurship, we shouldn't just be teaching, can you come up with an idea, but rather, can you sustain it? Can you run a business? And in looking at the syllabus that they provided, I would suggest that this is indeed business, but let's open it for discussion.
Madam Chairman, I would agree with that assessment, particularly when looking at the syllabus. It's not, I'm not sure how to, this is not working. Let's see if we can try the other one here. Is that a little better? There we go. So the syllabus to me is not dissimilar from other MAC or business graduate MBA or MAC courses that I've seen that have a concentration on entrepreneurial studies. And so I share your view that this is much more in common with a business course than not.
Other comments? Anyone care to speak on the other side?
Madam Chairman, I tend to agree with comments previously made. I just, your point around your basis for, understanding NASBA's denial of this do we get any affirmation from NASBA as to why they in fact did disregard this? In particular, it's curious if this course has been offered by many years at Belmont. Why now?
We haven't heard anything specific from NASBA, and the professor that reached out didn't have any additional context.
Okay.
I will say that we had a conversation about that at the last board meeting, and they talked about whether, if it's not specifically stated, that sometimes they'll deny it and send it back to the board for board to define whether or not it is or isn't.
For that last criterion, so other
Right.
topics as the board recommends. So I would move, I would move that we count this as a business course.
Second.
Do we need a roll call or not?
We can do one if you would like, but as you are all in the room, we don't need to. I'd be
Okay.
happy to do it for you, though.
All right. So all in favor, say aye.
Aye.
Opposed? All right, very good. The next topic is the Certified Information Systems Security Professional Exam. Now, this is before us to consider whether to count it as CPE credit. It's not currently a board-approved exam, but as Karen and Jen have stated, it's similar to those that we do count for CPE credit. Not academic credit toward a degree or anything. And it's a little bit different because someone had asked for this after the fact, but the rules say they must ask before they've completed it. And so Jen brought it to us to consider for other people in the same situation. So she said the requirements appear to be similar to others, and she gave us a list of those. Is there discussion?
Madam Chairman, it makes sense to me. I mean, I think the subject matter is highly relevant to our profession. It's, been becoming more and more relevant every year since about 2000. I think becoming certified in a specialized area, such as information systems, is by definition continuing professional education. I don't know why we wouldn't count, the examination, as credit towards continuing professional education requirements.
Okay. And I should have noted, credit is awarded at a rate of 5 times the length of each exam taken and limited to 50% of the total CPE credit according to our rule. Is there other discussion? Then I would move that we count this as CPE credit.
Can I also add, we would request that you decide which field of study
Oh, dear.
to assign this to.
Did-
And I can point you to that in the rules if you need to see the list.
Madam Chairman, may I point out that we have an exam on the list that is Certified Information Security Manager. That's under Management Services. So is that the category, then, Management Services? Is that a category? I think it is. So it would seem to be extremely similar to that.
I would agree. Certified Information Security Manager, that's the one that you pointed out. And this one's called Certified Information Systems Security Professional. It sounds very similar.
Agreed.
So I think we would be inconsistent not to put it there. So I move that we count it as CPE credit in the Management Services category.
I'll second.
All in favor, say aye.
Aye.
Opposed? All right, thank you. The third one is something you may not be familiar with. A foreign credential evaluation service provider. And we use these services for our licensed candidates who have completed education outside the United States. So I'm familiar with this just from evaluating transcripts when we get transfer students, et cetera. And Jen had checked it out and said that this is a service that we've used and are familiar with, but they're not approved, and it would simplify things to approve them as a group that we use without having to bring it to the board. Is there discussion?
Madam Chairman, I think it's important to note in the materials that were provided that there are other boards of accountancy around us who do use them.
Correct.
And they have noted
No problems.
no problems with the reports submitted. And in discussion with NASBA, it seems as well that there's been no
correct.
no red flags raised. So I just point that out. I think it's important to note that there has been some due diligence done around this group, and I think we should take that into consideration.
I appreciate that. Anything else? Then I move that we approve ERES as a foreign credential evaluation service provider for the state of Tennessee.
Second that.
All in favor, say aye.
Aye.
Opposed? All right, and then we come to the extension request. And as you know, some of you who haven't been on the board long may not know, but we've had lots of changes in how long is the standard rule for keeping credit. But these are, I think, unique situations, and what we always look for, of course, is are there extenuating circumstances? So the first one we will consider is Vikas Jadhoff. His BEC score expires 6/30/2025, and he's requesting a 15-month extension to 9/30/2026 for BEC due to medical issues. We did not put the personal details of the medical situation, but it was, Jen and Karen have the papers. It is indeed a very serious condition that he was diagnosed with shortly after passing which one? Shortly after passing BEC, that's the only one he has. And so it was right in the middle of his attempting to take others. It seems to me that this is a reasonable request in keeping with others we have granted. Any discussion? And he has been trying, but has stated that the medical situation has really been overwhelming. Anyone opposed to granting this extension? Well, I shouldn't ask it that way. Are there any points you have to make on either side of keeping or granting this or not granting this?
On the basis that we've received the medical documentation and that's been validated, I don't have an issue with
And serious.
with extending it.
Then I move that we grant the extension as he requests to 9/30/2026.
I'll second.
All in favor, say aye. Aye. Opposed? All right. One more. Also an important one. Also a credit extension, Daniel Swift. Daniel's in a unique situation. I should add to the documentation that he, in fact, passed BEC just this past December. He has requested to have an extension for FAR to 6/30/25. And his audit score was extended to that through the standard one-time credit relief initiative. And because he did pass BEC in December, if we grant this, he will have passed the CPA exam. And let me say, his medical condition would be classified as potentially life-threatening, and he was diagnosed with this right at, and what was it, 2019? Let's see,
It was a diagnosis in October of 2018.
2018, yes. And so, and it is chronic, still with him. I'm very happy to say, I won't reveal anything about his personal situation, but he's had some relief on that, and I'm delighted to note that, but it is definitely still with him. So is there discussion about this, about granting this? All right, then I would move that we do grant the extension of FAR to 6/30/2025 due to medical and also the COVID-related issues that he has gone through.
Second that motion.
All in favor, say aye.
Aye.
Opposed? All right. Thank you.
Thank you very much, Pam. Our next committee is the Law and Rules Committee, chaired by John Griesbeck. I will mention one item before you get started, Mr. Chairman. Kevin, I know that you spent an inordinate amount of time with our former director, Wendy Garvin, going through the discipline matrix. And in no way I asked that this item, or at least one of the items, be put on the agenda because of an email that I received with a request that we review something. So thank you for all the work that you've done. This is not on the agenda to undo any of that wonderful work that you did.
No worries there, and really the thanks goes to Gabe Roberts. He's really the founding father of the document, and then we've augmented it over the years, but we always reserve the right to get smarter, and
Yes.
heaven knows I need to, so no worries there,
Okay.
Mr. Chairman.
Thank you. And I'll turn it over to Chairman Griesbeck.
Thank you, Mr. Chairman. And thank you, Mr. Monroe, for all the work you did on that. I was just going to make a few brief comments to kind of tee up some comments or the email that our chairman has referenced by Jen in just a minute. As Kevin and Greg both mentioned, and it was noted in our handout, it was approved in October 23. It was an exhaustive review. We kind of went line by line, and really what we were trying to do at that time was make changes, generally consisting of increased dollar penalties in certain situations and/or disciplinary actions for violations. And also, I think we provided for a more consistent application. The rules generally, or our rules provide for civil penalties of $0 to $1,000 per violation. So you'll note that range on the matrix in addition to suspension or revocation, as the case might be. Also, as noted on the document, penalties are per violation, but each day of a continued violation may constitute a separate violation. And then the suggested penalties or actions are incremental in severity depending on mitigating or aggravating factors that may be present. So those of you that weren't around in October of 23, maybe that's a little bit of a backdrop. And so I'll ask Jen to maybe discuss the email that was received and how that might interact here.
Thank you. So the feedback that was received back in November was from a licensee who's involved in the peer review process and had raised the question of when it comes to our attention that firms are issuing attest reports without appropriately being enrolled in peer review, we assess them a civil penalty. We take them through the complaint process, the board hears the case, we assess a civil penalty in some cases. I think the concern was exactly what's already been stated. Is there a way to perhaps increase those penalties so that they might be more consistent with what the cost of a peer review would be? And that was the concern that was shared. So, Greg, I don't know if you have more context on that.
Yeah, so I think, and I'm paraphrasing, I don't have the email in front of me, but the individual was questioning whether it's just less expensive for a firm to take a chance on getting caught and then incurring a penalty versus spending for a small to medium-sized firm, I think, $8,000 to $12,000 every 3 years to incur that cost. So if the firm doesn't get caught, they've saved some money. If they get caught, then they've probably incurred the peer review cost plus penalty.
Just glancing at the matrix, it appeared to me that the last item on it, on the last page there, was the only one that I noticed was dealing with peer review as such. Kevin, correct me if I'm wrong from your study. And that's failure to comply with peer review requirements. And you can see the level of penalties ranging from $0 to $1,000, up to $1,000 per year missed, suspension or revocation. And my recollection has been when we had this situation in the past, if they missed a peer review, that we may have penalized them up to 3 years worth and required them to obtain a peer review and then get back to us on that. So I guess that's probably the specific violation that is being referred to and that we might want to talk about. In my own mind, I'm not, would like to know how we get beyond $1,000 penalty. Maybe there's something in the statute there, but just as far as what I'm familiar with in the rules.
Yes, sir. The limit is provided by the Tennessee Code, and it's actually not in the accountancy chapter specifically. It's in a broader part of the code, Title 56, Chapter 1, over regulatory boards. And that limit is $1,000 per violation per day. So that's where we get our number. Now, some particular regulatory boards have a more specific limit that might be a little higher that is provided under their narrow part of the Tennessee Code. But we have nothing like that for the accountancy chapter. So we go by the general limit of $1,000 from the regulatory board's provision.
If council does not object to this, I also might ask either Katie Cheek or Kara Fitzgerald, who administer the peer review program for the state of Tennessee, if you all have any comments on this. I don't mean to put you on the spot, Kara, but I guess I just did.
Chairman Gilbert, we're familiar with the administrative fees that we charge to firms to administer peer reviews. We don't get involved in the cost associated with firms engaging another firm to conduct their peer review. So I don't know that I can offer insight as to how the civil penalties may compare to those fees for a peer review.
And I should have asked that a little differently. I didn't mean for you necessarily to address the penalties, but are you seeing a lot of non-compliance in this area, or?
We see what comes before this
Okay,
board.
yes.
We don't know
Okay.
of other firms that are not complying.
Good. Thank you.
I mean, certainly not complying with peer review, in my mind, sitting on a regulatory board protecting your public interest is on some level an egregious act or, non-compliant nature item. I'm just not sure how we make it more punitive unless we get into suspension or something, non-monetary action. I don't know if it's something, Lee, that we can look into, or is it pretty much, no, this is the situation?
Well, as the code is currently drafted by the General Assembly, we are definitely limited to $1,000, but we can take a close look at the number of violations. We can take a close look at the number of days. We have to have evidence to support the board must have evidence to support any violation found and civil penalty imposed. I think there was one case this last quarter where there was a penalty that was calculated to be $5,000. That was just based on the unique facts of that particular case. So there are ways to analyze the case and for the board to impose a bigger dollar amount than $1,000. It just depends on the facts of the case.
Mr. Chairman, did I hear correctly that the maximum is 1,000 per day?
Yes, sir. It's per violation.
Per
day.
violation, per day. So if they were in violation for 180 days, what would be the maximum penalty? With one violation that was present for 180 days?
You know, that's a great question. There is an appellate court opinion in Tennessee that addresses that calculation approach, where you just take the start date and end date and just take the number of days and multiply that out. The appellate court held that whatever regulatory board is acting here has to have an evidentiary basis for finding each violation. And so just the mere application of math to a beginning date and start date is not enough. It's an interesting opinion. If you want me to report on it further, I could maybe give a little better understanding than my little summary here, if you're interested. But there are definitely ways to increase the dollar amount, but at the end of the day, the board is limited by the statute, which is $1,000 per violation per day.
Question.
Add a couple comments. For those that haven't gotten to meet me, I'm Kyle Johnson. I'm new disciplinary counsel with the board. I think I met most of you. But I've worked for the department for a couple years and other boards, and we have the same problem with proving a per-day violation. It is difficult to establish that evidence. For instance, for review reports that are issued, I think you would have to have the respondent basically admit how long they worked on that report or something of that nature. But to one of the comments, I think as an aggravating factor, and we do this in other boards, if there's multiple violations, and that's their second offense, third offense, then you would ultimately want to consider a suspension or revocation at that point for it to be, more egregious.
What about the number of attest reports that were issued during the period of noncompliance? Would those be individual?
Those would be individual violations, so you would be able to do 1,000 for each, and then if there were evidence of multiple days that those violations occurred, you could tack on an additional 1,000 for each day.
Yeah, because the way it's currently written, we're saying per year of missed peer review and not linking it at all to the number of attest reports that were issued while non-compliant. So it seems like there would be flexibility potentially to change the way that we review or consider, instances of noncompliance.
Excuse me, it seems to me that it's the measurement date, right? What date do we have notice, I guess, this is occurring? Wouldn't it, like what Sam was saying, wouldn't it be like the day the report was issued? Would that be like a measurement date? I mean, there's a date on the report, and so we know when it started, at least, and they would have had some sort of work prior to leading up to the date the report's issued. It has a date on it. Is that not a proper measurement date, I guess, is the question.
I see what you're saying. In my mind, it's what days the violation occurred. So the violation would be issuing, for instance, the review report. And so we would have to have evidence of, I think if we found out how long it took them to conduct that report and issue it, we could probably consider that multiple days. But I don't think we can just say that how long they haven't had peer review. To that comment, we would have to know how many attest reports they issued and consider the dates of each of those and how long they took to prepare and issue.
So question, so they enter an engagement letter. So the engagement letter starts on day one. They have to document their hours. So what you're saying is if there's 8 hours in a day and they have, 80 hours in it, that we could go back to the engagement date, come back to the date that they issued the opinion, and if they had 80 hours in it, then we could do 10 days at $1,000 a day. Is that what you're implying?
Exactly. The struggle is, though, getting that evidence to prove that, which we can attempt to do. But if we have evidence that, for instance, it took 80 hours to conduct that report or issue that report, then we could use those 80 hours, which I can't do the math in my head, but however many days that would be.
Well, the good thing is most accounting firms keep a document record of the hours on the engagement, and they also estimate the hours on the engagement.
Well, that may be true for those who are compliant. Those who choose to be non-compliant may not have the same level of rigor as maybe those of us are accustomed to. I think the suggestion that Sam made regarding if you are out of compliance and you issue a report, regardless of how long the report took, that you could reasonably assess a $1,000 penalty, again, if it's within the statute, for every review, audit, or other attest report issued when you're out of compliance. I would hope at a minimum they would have a record of what they've issued, even if they don't have good record keeping around how long it took them to issue those reports.
May I, I'm sorry, are you?
Oh, I'm sorry, yeah, go.
Let me clarify what I said. So the peer review violation is going to be based upon someone issuing a report, right? And that report is dated October 13th, 2024, whatever that date is. That's the date I'm talking about. That's got a date on it. And that could be, and today is, February the 3rd or 4th, whatever it is, that's X number of days. Or is that 30 days? Or excuse me, maybe like 90 days?
In my mind, the violation is only occurring when they issue the report, so I don't.
Well, that's what I'm saying. The report would have been issued, it has a date on it.
Mm-hmm.
The financial statement that they issue will have an issuance date on it. Isn't that the report date, isn't that proof that that's when it occurred? Because they signed off on it on that day.
I believe so, but you can only count it for that date. So if you're wanting to prove that more time occurred and tack on additional days, we'd have to have evidence of that. But
Oh, okay. So we can establish the front end, but I guess the back end. When does the measurement date stop? I guess when maybe a violation, when someone issues a complaint about it.
If I may, so the case I talked about earlier, it's from the Court of Appeals of Tennessee called Rowden versus Board of Examiners. It's medical. In that case, a pharmacist was alleged to practice medicine without a license. And there was a fine imposed, and it was calculated based on a start date and an end date. And the the Court of Appeals held that that was insufficient. It was unlawful. And I'll just read to you the reasoning of the court, and it might kind of shed light. And the ultimate point I'm trying to make is that it's very fact-specific and fact-dependent. So here in this case, the record shows that the board's determination that Dr. Rowden was guilty of 12,710 violations was based on the number of days in various time periods during which he either saw patients or treated patients, rather than the actual number of patient visits or treatments. The number of days in each time period measured by the board is not substantial and material evidence in support of its finding of the number of violations. So in other words, it's not just a simple matter of picking two dates and counting it up in between. We have to look at the actual conduct involved. But I think there is a lot of room to explore that in each case. It just depends on the facts.
Well, what you just read to me sounds like you could establish if a report was issued that there is an act that can be proven, and notwithstanding, that a report may be relied upon thereafter by a party, and that's maybe a little bit more ambiguous, but you could certainly, I think, establish a basis based on what you just read, that if I issue a report and I continue to issue other reports when I'm out of violation, that each one of those would constitute a separate violation.
Yes, sir.
Or that could be the measurement date. they issue 5 reports, starting up, let's say, October 13th. 5 reports get issued between then and June 30th of the next year. Is that your measurement? And then they get caught and they stop. Is that the measure? Could that be the measurement period?
Yeah, it's just per violation per day. So, and I have to say, if we look at a plain reading of the statute, per violation per day, it does make it sound like you can just go with a beginning date and an end date and count all the dates in between. But then the Court of Appeals comes along and it looks at that language and says, wait a minute, you have to establish factually what each violation was. But, again, I think it's fact dependent.
So in the Court of Appeals case, then the pharmacist had 12,000 days beginning to end, bookends, of when he was doing this allegedly, or I guess he did do it. But we don't have how many times he did it during that 12,000 days. That was the problem.
That was the problem. They said
Okay.
just
All
counting up days mechanically is, quote, not substantial and material evidence.
Yeah, so our situation's a little different because, to Andy's point, there would be an engagement letter, even with the least sophisticated firms, I would imagine, that would be summarizing the terms of the services to be provided and the fee arrangement. And so at a minimum, it seems the engagement letter date to the report date would be a reasonable way to calculate the number of days.
Oh, I
Because you
certainly think that's worth exploring.
Yeah.
It kind of depends on the facts and,
Well, they wouldn't
It's
be
kinda hard to
licensed to,
generalize.
they would be out of compliance to engage in attest services if they're not in compliance with peer review.
Yes,
Or if
sir.
they don't have a valid license.
right, yes, sir.
Well, another way to look at it is we can have our investigator look at the actual documentation, whether it be electronic or manual, of the dates that people signed off on it and the date that they put that day. So each date that they signed off on a working paper, or whichever method they used, that would be a date of a violation on an attest service.
It could be, again, it would be a fact-dependent inquiry and very much dependent on the details. But I think that's exactly the kind of analysis that we can employ to try to, for the board to impose whatever civil penalty is appropriate to the situation.
Well, if the original question or original thrust of the comment was to make noncompliance more painful than it is currently, then, and I'm sympathetic to that point of view. However, if you were to apply, and let's just say it's a quarter, if you were to apply this begin period to end period, I don't think, I guess I'm saying if we were to apply $1,000 a day over a quarter, that's a $90,000 penalty for something that probably is, I don't know what the engagement fee would be. So I guess I raise this only in the sense that if we have a day count basis, because these reports, as we know, these reports can take a long time to actually be issued, and then they can also be relied on until they are issued again, so up to a year. Then if we have a unreasonable basis on which we calculate the fee, I would imagine, Lee, you can tell me that a court might strike that down as being unreasonable. Again, a court would throw out, even if we had a good basis to say we could calculate it on a day count, if it was into the tens of thousands of dollars, I would imagine a court would look at that as being unreasonable, but you tell me, I'm not a lawyer.
Well, what if you capped it at the fee collected?
Well, okay. Yeah, so there's all sorts of ways you could deal with that, but.
That would seem fair to me.
But,
And we do in the matrix have the ability it's 0 to 1,000. So we have the ability to adjust that fee per day working on that.
understood.
Test.
I would say we want to be careful about going $1,000 a day for many of these reports.
Would there seem to be any grounds, as Sam mentioned, based on attest engagements? The rules say a firm that performs one or more audit engagements shall have on-site peer review. And that's what they're not doing, is because they did one audit engagement or 12 audit engagements. Is there a way to tie it back to that? So the more they do, the more they're going to get hit, obviously.
Yes, sir. I think that's exactly the kind of fact-dependent situation worthy of exploring in an effort to hit the bad actors with the civil penalty and the worse actors with the bigger civil penalty. I think so.
Or potentially suspension if it really got egregious.
Yes, sir.
You know, to the comments too raised about the matrix, it says $1,000 per year. Is that something that it shouldn't say or needs to be clarified somehow, that per year? Are we limiting ourselves somehow, or it's not not compatible with our, you know, our rules and our conversation here?
Well, I do think, you know, as a guide, it's helpful. I think that stating per violation, you know, is probably the more accurate way to phrase it if you just start using the statutory language. And you're right, it might be a limiting factor unnecessarily, but again, this is just a guide.
I mean, we say per violation in the guidelines and at the top of the column, you know, there, but then we say that $1,000 a year, it almost sounds like we're going to limit it to that. And we even say $3,000 per year because of the 3-year renewal nature. So it may be that as we explore this, we should consider revising that.
Mr. Chairman, can I add something? Having investigated these for a couple of years now, the medium to large size firm not being in compliance with peer review is few and far between for what we've seen in the past couple of years. Has happened on an occasion, but we've dealt with it. Bigger concern I have generally is when I go through this work is our individual licensee going out on a flyer and doing their own attest engagement on their own as a side work or helping out a friend or something like that. One of the things I always do when I kind of look it up is, you know, their most recent license renewal, they check off that they've done the, you know, the Tennessee specific CPE. And within that, it's very detailed in terms of who can and cannot do a test work. I just wonder if in those situations, would additional CPE to help hopefully reinforce those, would that be, it might not be a monetary fine per se, but it might drive the point home a little bit more. And I don't know if that's allowable along with a monetary fine. Because generally when I do ask our individual licensees that question, you know you're not supposed to do a test work if you don't have a firm, you're not registered for peer review, you know, they seem to act shocked most of the times when it's clearly part of that Tennessee specific that we have to take.
Yeah, we certainly have a history on past occasions of mandating additional CPE, such as the NASBA 3-part ethics course, in addition to whatever, you know, other punishment or civil penalty we are offering. So we have at least historically employed that.
And the rules seem to probably provide for something. I mean, it's pretty general in that we may, in addition to or in lieu of any other lawful disciplinary action, assess civil penalty. So it feels like we could require additional CPE or other actions. I'm not sure what the committee thinks. I'll just throw out that maybe it would be good to and look for Chairman Gilbert's and Jen's thoughts too, to explore this a little further. You know, to Duke's point, it's not happening every day. You know, these are the only ones we find out about. But the ones where we do, you know, if it would give us a little more leeway to properly address such a violation, and then maybe even any suggestion as to the actual matrix itself and the language in that. I raised the question to Jen earlier as I was sort of thinking through this. Is this matrix actually a policy? And if so, should it be set out as a policy? I think in our materials there were 3 that were set out, so maybe that's a legal or technical question. Do we need to move? Would we need a motion from the committee here to request some further study on this, to then make a recommendation to the board?
You're free to do so, but I've got my marching orders pretty clearly. I'll definitely look into it.
Yeah, my only other comment would be, I'm having a hard time, I guess, understanding why we would apply, that level of civil penalty to not complying with peer review and not apply something similar to someone attempting to use a license or attempting to use their certificate when it's been surrendered, suspended, or revoked. Right? I mean, that actually seems probably more egregious than not complying with peer review.
Where's that, Sam?
That's four line items up on the matrix. It's .03C2. So we've got that's only a 750, or that may be 1,000 per instance, I guess. It just says 1,000. It seems like whatever we concoct for the peer review would seem to make sense to apply to those that have had a revoked or suspended license that are using it for test services.
Mr. Chairman, I think maybe in addition to the legal review that council is going to be doing, it's probably been roughly 2 years since we've had a good scrub of the entire discipline matrix, and maybe it makes sense to work with Jen as executive director to kind of do a scrub for consistency for just the types of items that Mr. Bennett is pointing out. And then maybe at a subsequent board meeting, we can just refresh the entire matrix where something seems out of whack like that.
Any other thoughts on that, or any thoughts that haven't been presented yet from the committee or anyone else?
Would it make sense to, we live in a time of abuse, and abuse technology-wise, where people take advantage of the system, represent themselves to be different professions, and that are not licensed. Email has really opened up, and phishing attempts and all kind of false things that you get from advertising falsely and other things in professional, in our professions, to where maybe it's costing us right now so much to investigate these and to bring them before the boards, not only our board, but every board, but maybe asking the administration to consider looking at the $1,000 per occurrence. Because that may have been done some time ago. And I know that we as boards have a lot of attorneys that work for us. And it just seems like sometimes we've got the bar set so low that, that who cares if I got to get a $1,000 penalty? I can just keep on doing this. And it seems like it would give not only our board, but other boards more meat, to actually sink a penalty into. But that's just a thought. I don't know how you go about that. I mean, obviously the administration knows that that's the limit. But maybe the code overall maybe need to be looked at.
I've had a thought, and then I looked at the the cover page of the civil penalty guidelines, and there's a line item on here which interested me. The cost of the investigation, formal hearing, and administrative cost, if applicable, will be imposed independently of the civil penalty. Do we ever actually do that? We say, oh, here's your $1,000 penalty, and oh, by the way, it costs us $5,000 to investigate it. Here's your $6,000 penalty. Here's your invoice for $6,000.
A lot of these cases are resolved on consent order, which is essentially a settlement, and the settlements, in my experience, don't include that. It might be something that's sought if we're forced to go to a formal hearing, but I can't speak to how often that's done.
Well, I mean, how much does it cost to send Duke out there? I mean, how many $1,000, couple $1,000 does it cost us in his wages and mileage and whatever to go investigate something like that? If we start really, we're accountants, right? I mean, we could start accounting for that and issuing that with a $1,000 fine, and that's going to be a lot more than the fine. I would think. I mean, look at everybody's time here. Everybody's got an hourly rate. It's easy to figure that. Whatever your salary is divided by 2,080, and there's your hourly rate, and let's apply it like that.
Well, and there's a statute that specifically allows what you're saying.
I mean, it says right there,
Well,
right? I mean,
that's a matrix, right?
well,
that's-
it's on the front page of the civil penalty guideline.
Does it cite the statute?
No, it just says the cost of the investigation will be imposed independently of the civil penalty.
And that is absolutely consistent with the law. I mean, the law allows the board to impose, and I quote, all costs of the proceeding. That can be added.
That's more than $1,000, I guarantee you that. So why don't we see how hard that is to do next time we investigate one of those and just track everybody's hours, just like, cost accountants do. My son's a project coordinator. That's all he does is track people's hours and what it costs. So, and he's an engineer.
Well, that's a great idea. And may I speak to your point also, Mr. Bonner, that, basic separation of powers, the administration enforces the law, that's the executive branch. The legislature makes the law. So if an effort needs to be made to lobby the General Assembly for some change in the code, there are entities that can do that. The TSCPA might be the appropriate entity to do that. Of course, the board here enforces the law. So whatever the law is, you enforce it. And that's where your limit stands. As long as the code is written as it is, that is what you are enforcing.
Andy, I was just looking at the rules here, and on that section where it lays out 0 to 1,000 for all the violations, it appears it's been at least since 2006 since that was amended.
So some time ago. But I also know that the governor will actually bring legislation, submit legislation. It's called administrative consideration of a bill. And so that's what I was referring to.
Yes, sir.
So they can't pass it, but they can ask them to look at it and for consideration to see if they voted up or down.
So I guess just to wrap up this committee's deliberation, Lee, you will explore this whole peer review area and the violations and maybe give us some grounds for how we might revise it going forward. Also, I think to Mr. Monroe's point, another look at the matrix in
Yes, sir.
general may be a good idea. And, particularly some of the ones in light of Sam's comments also.
Yes, sir.
Chair Griesbeck, I just have one last question, and this is following on Board Member Zvan's point about the costs associated with these investigations. And the comment was made that we settle most are settled via consent order, and that's a negotiation, I take it, with the actual the other party. So is the cost associated with the investigation, has it historically not been part of the consent order negotiation? Or have we attempted to recover those costs and just found that it was too difficult and therefore just, for lack of a better term, defaulted to the matrix that we see before us?
Well, I'll defer to Mr. Johnson. He has more experience, but I can tell you in my experience, it has not been included at all in the settlement proposal, the draft consent order. But it is mentioned in the cover letter, which is to say, if you don't want to settle, we can go forward with a formal proceeding, and the formal proceeding may include an application of costs. But
So historically, across all the boards, they have waited to assess those costs once a formal hearing action is initiated. At that point, we typically tack on all the investigation costs and attorney's fees too. We're looking at that. But this is a topic of discussion between a lot of boards about how to get these fees up, whether it's the civil penalty or costs. So I think the board has the power to start looking at assessing those at the consent order stage, but you just want to be consistent, just like you have been with the civil penalties on calculating those costs, and I think that's something that probably can start to be done.
So I may be jumping ahead here, but as we have consent orders at this level and we approve them, penalties, would we also have to have a provision to provide for expenses to be reimbursed, cost? You know, we usually say, okay, it's $1,000, consent order, whatever. Would we have to say $1,000 plus cost, maybe?
Yeah, I think you'd have to distinguish between the civil penalty, which is the $1,000 in that example, and then costs, and bifurcate those and present those separately so that it wouldn't appear to a court that we were going beyond the $1,000 limitation in the statute.
Yeah, I think the decision could be authorize a civil penalty for $1,000 and assessment of costs. Investigation costs is what you'd put on the report.
Okay, barring any other discussion, I would recommend that we explore with Mr. Lott some of these options and also with Jen, and we'll recommend that to the board tomorrow. Do we need a vote? Are we good on that?
I think you're good. I think.
Yeah,
we
I do not believe you have to do a vote. You certainly can, but I do want to clarify. So are you looking for some type of report and an analysis investigation done for tomorrow's meeting? Or are you saying that at tomorrow's meeting, you will have to address it in a limited capacity, but then address it further at the next quarter?
Yeah, well, I think tomorrow, just recommend that we give you these marching orders and you can get back to us, you know, at the next meeting with some recommendations
Yes, sir.
within the statutes. Thank you.
Understood.
Thank you, Mr. Griesbeck. At this point, I would turn the program over to Chairman Kevin Monroe of the Enforcement Committee.
Thank you, Mr. Chairman. So we've got really two items under the Enforcement Committee. The first is the summary case and complaint report, which shows the detail on open complaints, but note that these complaints do not include those that we will be dealing with in our next action items. Obviously, some are aged, but those are primarily all litigation monitoring, and we're just waiting for that litigation to come to some type of conclusion. And so this is just an information item. No action is required. With respect to the legal report, which carries the cases that we'll be acting on, one item of note is that in the proposed discipline cases, case number 9, we are going to pull that out of the committee's consideration this afternoon because that's going to be treated in a bit of a different way tomorrow. Kyle, I don't know if you want to address that now and just kind of give us an overview of what and why, but because tomorrow the board will be acting on that matter before we get to the Enforcement Committee, we thought that the best thing to do was to deal with it in that action rather than discuss it this afternoon as a committee.
And I could jump in and give a little more context. So there has been an update to this case with recent information. Considering the recent information, we have set an informal, a summary suspension informal hearing that will take place tomorrow over this matter. And I'm not sure if this board has ever considered that before or has done one of those. But to provide some more context, pursuant to statute, this board has the power to temporarily, emergently suspend a license pending further action when it finds that the public safety and welfare require that emergency action. It does not happen a lot. It only comes up in very rare circumstances, but we believe this is a case that the board should consider that. So there's an informal hearing set for tomorrow over this matter. The only sole issue at the hearing will be whether the public health and safety require the emergency suspension of this license pending further action, whether that be revocation down the road or some other action. And so my recommendation now, considering that update, would be just to consider the whole matter at the informal conference or hearing tomorrow. And if there's any questions on that procedure, I'm happy to discuss.
So that is what we will propose to do on that. So we will not be considering case number 9 this afternoon in our committee vote. The first set of cases, the first 6 cases are consent agenda items. These are cases typically where there is a recommendation for closure or no disciplinary action. And so we'll highlight those, and what I would do is just summarize those and then ask the committee members to vote in total on the consent agenda cases. If there's any individual case that needs to be pulled out or discussed separately, we can certainly do that. Just let me know. The first case is a due care case, and it's just basically relating to differences of view between the complainant and the respondent over the completeness of a notice of canceling the engagement. And one party viewed it one way as being limited to only part of the engagement. The respondent viewed it that he was canceling the entire engagement. And after investigative review, it was determined that there's not enough evidence to establish that there has been a violation with respect to due care on case number 1. For case number 2, this is an unlicensed activity, and after investigation, there's not enough evidence to proceed against an individual license. However, as indicated here, a separate complaint is being opened against the firm relative to this matter, and that is not ready to present at this session, so this will likely come up at a subsequent board meeting. But as it relates to the complaint against the individual licensee, that is closed, or recommended for closure. The third case is also another due care case and also a fee dispute. As we all know, fee disputes are not in the jurisdiction of the board. We don't address those. And with respect to the investigation that was performed, there was just not enough evidence to support a finding against the respondent. So the recommendation here is for closure on case number 4. Case number 5 is essentially a fee dispute for which we have no jurisdiction, so the recommendation is to close that complaint. And case number 6 is relating to potential unlicensed activity. And the issues here for us are that we really don't have jurisdiction over the matter. In this case, the respondent is not licensed by the board, but also based on the allegations, there is no unlicensed activity for which the board would have jurisdiction because the services do not amount to attest services. So the recommendation here is to close that complaint. So in summary, for the first 6 complaints on the agenda, on the consent agenda portion of the disciplinary report, the recommendation from council and board leadership, executive leadership, is to close those complaints. Let me stop there, and I guess let's take a motion on that. Is there a motion to accept the recommendations for closure for those 6 complaints? We'll take a motion in a second and then discuss.
I'll make a motion.
Okay, so moved by Mr. Bonner. Thank you. Is there a second?
Second.
Seconded by Rob. Thank you. Any discussion with respect to the consent item, first 6 cases? Hearing none, Karen, are all of the committee members, I guess we're all present here, so we can just call for the vote. All those in favor signify by saying aye. Aye. All those opposed say nay. Okay, so that motion passes. We'll now go to the next batch of cases. These are proposed disciplinary cases where there is a disciplinary item or punishment being proposed for those cases. And we will deal with cases 7 and 8, and then 10 through 13. As indicated earlier, we will not address case 9 in this. With respect to case 7, this is a CPE deficiency case for which the standard discipline on the existing matrix that we have is being proposed on this one. And specifically, council recommends that the board authorize a formal hearing with settlement authority via consent order requiring the respondent to pay a civil penalty in the amount of $1,000 for violation of the CPE requirements under the cited codes, and to voluntarily surrender and/or agree to revocation of a CPA license unless he completes all 2022-23 CPE requirements, including any penalty hours that apply under board rules, within 90 days of the execution of the consent order. The next case, item number 8, is unlicensed use of the accounting designation for which standard disciplinary matrix discipline is recommended. Specifically, counsel recommending that the board authorize a formal hearing and settlement authority via consent order requiring respondent to pay a civil penalty in the amount of $1,000 and to remove the term accounting from its logo within 60 days of signing the consent order. For case number 9, as indicated, we will not discuss that one this afternoon in committee due to the action that we'll be taking in the informal conference tomorrow as a full board. Cases numbers 10 through 13 are all cases where attest services were performed without a firm permit or peer review. These were all contractors licensing board cases, and as we have discussed before on many an occasion, to their great credit, the contractors board does a great job of detecting these violations after the fact, after they have occurred, and dutifully sending us the complaints so that we can take the appropriate action. And we will, I'm sure, endeavor to do so today. It is our hope and sincerest desire to work with the contractors board and other Department of Commerce personnel to see if there is any way we can try to prevent this behavior from going on the front end rather than having to clean it up on aisle 2 on the back end after the violation's already been perpetrated. So the standard discipline recommendation here is in each of these cases, 10 through 13, I believe. All of these are recommendations based on the facts for penalties ranging from $1,000 to $1,750. That concludes the proposed disciplinary section of cases, items 7 and 8 and 10 through 13. I would accept a motion to accept as a recommendation to the board the recommendations of civil penalties as prescribed for those cases.
Kevin, can I ask a clarifying question? The ones that all do with the peer review on basis of contractor's license, the penalties are stated there. It appears that maybe there's more than one violation there. Could they be spelled out separately? It seems like we've generally done that in the past. For instance, it says $2,000 on number 10.
Yes.
Is that in effect two $1,000 penalties?
Oh, I see what you're saying. Let's see.
Seems like in the past, we've generally noted each violation and what its specific penalty was.
That's a very good point. Here, let's just
It's a little
take
easier
a
to
peek.
tie back to the matrix on the basis on which we're
I can
imposing
provide
the-
some clarity on that.
the penalty.
It is 2 separate violations, but in the future, I will definitely spell that out so you guys know which ones are for which.
And on number 10, I was wondering, the history showed that he had a CPE compliance, he or she, I don't know who it was, requirement violation. And then on the paragraph just before the recommendation on number 10, it said aggravating factors, issued a letter of warning in 15 in conjunction with a prior complaint regarding firm permit requirements? Were they
Yes.
two
and
different things in the past?
In the past, he was issued a letter of warning with a prior complaint that basically stated to him and reminded him of the firm permit requirements, and so that's why I thought that was an aggravating factor that would bump that up just a little bit than the standard 1750, since he's been warned in the past of it.
Yeah, I guess my question was on page 9, where it's first introduced to case number 10. It says history 2015, and it says there was a penalty imposed for related to CPE requirements.
That must be an unrelated matter. That
So I didn't
it
know,
wasn't
maybe they were
something that
really two different things or something.
I believe so.
So good points. And so particularly for the recommendation in number 10, if we revise that for tomorrow's final consideration by the board, if we could just break out or specify that that was two separate violations.
Sure. Would you
Yeah.
like me to just spell that out for the board tomorrow verbally, or can we even amend the report to do that, I think?
Typically, what we do is we'll redline the report overnight and then to address that.
Perfect, will do.
It appears it may apply to 11 through 13 also.
Yeah, let's take a look at that, because I think you're exactly right, John. Yeah, so please, if we can, just look at each of those.
Yes, sir.
And I don't sense that there's discomfort with the overall recommended civil penalty. It's just a matter of laying it out in detail that it's more than one violation. All right. So is there a motion to accept the recommended discipline for cases 7 and 8 and 10 through 13 with, as modified in 10 through 13 to clarify if there are multiple violations for which, or multiple instances for which civil penalties are being assessed?
So moved.
Thank you. Is there a
I'll
second?
second it.
We have a motion and a second. Is there any further discussion or comment or questions on any of these cases? If not, all those in favor of the motion on the Enforcement Committee, please say aye. Aye. Any opposed, say nay. That motion passes. So now we're going to move to the representation cases. We have 4 of those cases, although the first 3, items 14, 15, and 16, are related. And I may, just to kind of put council on notice, I may ask just for questions on or for a potential response about how cooperative the PCAOB has been with us in sharing information when we get to that. But the first items, 14 through 16, are related to a PCAOB disciplinary matter where they assessed a civil penalty against a firm as a respondent, and I believe they also assessed penalties against individuals in this particular case. So the penalties ranged in amounts from $2 million to $35,000 on one partner and $25,000 on another partner. And in addition, one of the partners' activities was limited with respect to being associated with audits that are subject to the Sarbanes-Oxley jurisdiction. And so the recommendation in each of these cases is to close, in other words, not to impose any further discipline beyond what's already been imposed by the PCAOB. And I think the question I would direct to council is, in the past, we have had difficulties. I mean, the PCAOB will publicly, complain that state boards are not following through on discipline based on the cases that they are referring to state boards. Okay, fair enough. But at the same time, in many instances, they are not providing enough detail for us without having being an independent trier of fact and having to redo what the PCAOB has already done, to impose further discipline. And so my question is, has the PCAOB had a change of heart? Are they providing us with detailed information that would enable us to make an independent view and act independently as a trier of fact if push came to shove?
Mr. Monroe, I'll speak briefly, and then I'll defer to Mr. Speed, who worked closely on this investigation. But I'll say in short that there was no change of heart. They simply forwarded a report and said, we're supposed to give you this report, here you go. So, but for further details, Mr. Speed may have more to say.
So in this instance, this was the first one of, I guess, audit failure, we'll use that phrase, that I've seen. So I had numerous conversations with them. They were very willing to work with us. When it came to information sharing, again, willing to work with us, but we're restricted. So it's confidential by Sarbanes-Oxley, so whatever I've seen, we can't publicly disclose. But they were very cooperative, and was able to kind of review what was done. So the information sharing was there.
Okay,
And there would have been a basis to do something more if we needed to.
okay.
I'll say that.
So I guess another question along those lines was, I gather it's your recommendation that based on the actions and the discipline that had already been meted out by the PCAOB in this case against the respondents, their staff or legal counsel is making a recommendation that there's no need to pile on, if you will.
That's exactly right, yes, sir.
Okay.
And I attempted in the summary to provide some context. There are lots of potential violations involving various levels of culpability and misconduct. And this one, it looks like it's a kind of strictly narrow order from the PCAOB based on professional standards and technical matters that are beyond my expertise, but you would probably be very familiar with them, having to do with revenue estimations and revenue collection and things like that, it seemed like the PCAOB order addressed and fined heavily. And so I think anything further is unnecessary, and it would be probably best described how you just did, piling on.
Okay. All right, so I just wanted to try to clarify that because that's often a point of contention, I think, between the PCAOB, at least in some of their public policy statements about reasons for inactivity by state boards on a disciplinary process. I think the point I'm trying to make is we generally do take their actions seriously and their referrals seriously to us. We try to also adjudicate based on the penalties that are already assessed in their actions under their jurisdiction, and seldom do we find a need to pile on. Obviously, we can't issue a $25,000 civil penalty for one violation under the statute here, even if we wanted to, as we just discussed. And so those are, I guess, the summations of cases 14, 15, and 16, which are recommended now for closure. Previously, they had been in litigation monitoring pending the outcome of the PCAOB proceedings. And so those are those three items. The last representation case with respect to case 17 had a lot of traffic down this roadway, and I guess Lee or Kyle, I might ask if you could just summarize kind of where we've been and why the basis for the new information and new recommendation to put back in litigation monitoring.
So in a nutshell, this particular respondent was accused of stealing $125,000 from her aunt. She was not acting in her capacity as a CPA. She was acting under a power of attorney that she had arranged in her family. She was supposedly acting for the benefit of her aunt, but she allegedly, I should say, stole $125,000. Now, that matter is still being investigated. It's being addressed on multiple courts. There's a probate court. In that probate court, there was a finding. There's now a criminal court, but I'm really not going in chronological order. Let me go in chronological order. Starting out, she was accused by another cousin of taking this money. A probate action was filed. While that was pending, this board decided to place the matter in litigation monitoring. And then the probate court issued an order. It was on a default judgment, basically finding that she had, in fact, wrongfully taken funds that were not hers from her aunt. And after that finding by the court, this board looked at the matter a second time, and the board decided to authorize discipline and settlement in the form of voluntary surrender of license. And we approached the respondent with the offer of settlement. She rejected it. In the meantime, in November, the authorities in Memphis arrested the respondent. She was arrested based on a warrant out of General Sessions Court. And Mr. Speed has spoken with the prosecutor. I've spoken with the prosecutor twice, once even today. And that criminal case is ongoing. Currently, the respondent is undergoing a mental evaluation. Typically, those are a one-phase evaluation. This particular one is going to go into a second phase. And then after that, the case can be presented to a grand jury, and the respondent may face an indictment. So the recommendation I have here is at the conclusion at this chronology, I'm recommending litigation monitoring simply because the criminal case is ongoing.
Thank you for that summary, and it was very nicely done, given the kind of the past history of this particular case.
I'm sorry, sir, I did not hear that.
I just was thanking you for that summation of kind of the road that has been traveled on this case, so thank you
Yes, sir.
for that. So the recommendation ultimately is to put it back into litigation monitoring pending the outcome of the proceedings from a criminal and I guess evaluation perspective of the respondent here. So in summation, for the representation cases, items 14 through 16 relating to the PCAOB referral, the recommendation is to close. And then for item 17, the represented recommendation is to put it back into litigation monitoring. Is there a motion to accept those recommendations? I'll take a motion in a second, and then we'll open it up for discussion.
I'll make a motion.
Moved by Mr. Bonner. Is there a second?
Second.
Seconded by Mr. Floyd. Thank you. Is there any further comment, question, or discussion? If not, we'll go ahead. All those in favor of the motion, please signify by saying aye. Aye. All those opposed, say nay. The motion passes. Mr. Chairman, that concludes the Enforcement Committee report.
Thank you very much, Mr. Monroe. One thing that I would mention, and you may have mentioned this, and I missed it, you probably did, but if you take a look at the legal report, so first page, case number 1, after the case number, you'll see the parenthetical initials LL, so that's Lee worked on that case, and then Kyle did some of the other cases, so that's how you can tell which attorney worked on those cases for us. But and thank you, gentlemen. Those are very well done. At this point, if everyone's okay with it, I thought we might take maybe a 10-minute break, and then we'll move into the executive committee.
client that's based in Ireland, books and records are in New Jersey.
Okay, thanks everyone for being back in a timely fashion. And we have one more committee to report this afternoon. Before we really get into the meat of that I'm going to ask Jen to lead. I do have some information that I want to just read to you, and it's part of, it gives you an insight as to something that's been going on for the last couple of weeks or so. Representatives from the Tennessee Department of Commerce and Insurance and the Board of Accountancy, including Reed Witcher, Assistant Commissioner, and I think most of you have met Reed, but including Reed Witcher, Assistant Commissioner for the Division of Regulatory Boards, Candace Dawkins, Legislative Director, Jen Binkley, our Executive Director, and myself as Chair of this board, attended a self-sufficiency hearing before the Joint Government Operations Committee on January 27th of this year. By statute, any regulatory board that runs a deficit for 2 consecutive years is required to be reviewed by a joint evaluation committee during the legislative session following the second consecutive year of deficit. So since our board had small deficits for the fiscal years ended 2023 and 2024, we were required to attend a hearing this year. And no action was taken by the committee as a result of the proceedings. It was a very educational process for me, and I was there serving as your representative. And I will say that several of the healthcare committees or boards were chastised somewhat, possibly because they either didn't have board members present to represent the boards, or the board chairs were not there. So luckily, Jen convinced me it might be a good idea for me to drive over and represent you. So I was very glad that I was there. But again, it was very educational. The Joint Ops Committee members, which as I understand it is representatives, House representatives, as well as senators for the state senators, are on the Joint Ops Committee, and some of the questions were very enlightening. A lot of questions came up about reserves, and maybe not that reserves were inadequate. In some cases, possibly they were, but some of the boards maybe had too much in reserves, and some of the representatives felt that possibly those fees should be refunded, which would be tough to do administratively, of course. But on our behalf, Reed Witcher answered most of the questions. I think Jen answered 1 or 2 questions, and I was asked a question, but Reed intervened quickly and answered it for me. So that was very good. But anyway, I want you to have that overview because it appears that we will have a deficit for this fiscal year that ends June 30th, and then without substantial action by this board, we also may incur a substantial fiscal deficit for the fiscal year ending June 30th, 2026. So just wanted you to have that information overview. There was talk in the healthcare board hearings about a formula for reserves, and Jen and I, neither one really knew what our formula was, and if we have a formula. And when Reed presented on behalf of all of the boards under Department of Commerce and Insurance, he stated that typically the boards that fall under his jurisdiction have reserves of 1 to 2.5 times annual revenues. So our reserves are $1.5 to $1.6 million. Our expenses are about $1 million a year, so we would be in that range, but that is a wide range, and I've not spoken specifically with Reed as to where he thinks our board should be, but anyway, that's just some broad information for you as we go through some of the financial information. Jen, I'll turn it over to you.
Thank you, Chairman. The first item that we will go through is the travel report. So you should see a detail of travel completed by our investigator in Q4. Duke came, at my request, Duke came to Nashville in December for an all-in team meeting, which I think was very beneficial to have him and our licensing team all together at the same time. And then he also traveled in October for a department-wide town hall meeting. Any questions on that? Okay. All right, next we'll go through fiscal '25 fiscal results through the end of November. I think what I would like to highlight here is that just a reminder that our revenues from our renewal cycle that happens in November and December, those revenues typically hit our financial statements a month in arrears. So we'll see a pickup, and we should see a pickup in December and likely in January as well. So I know we're showing in it that we're in a $248,000 deficit at the end of November, but we expect to see that decrease as revenues are applied. Any questions on FY25? Okay. All right. I think if we're ready, Chairman Gilbert, would you like me to walk us through the budget for FY26?
Yes, please. Jim, before we do that, though, do you have a feel as to where we could end up this fiscal year?
I think without having seen renewal revenue yet, it's hard, it's maybe a little early to tell.
Okay. Thank you.
All right. You should see in your materials a budget that includes 2 years of actuals, so FY23 and 24, along with our FY25 budget and our proposed FY26 budget. There's also a narrative that's included that has a lot more detail, some of which I will read to you now, that explains how we got to the FY26 proposed budget. So our proposed revenues include licensing revenue only. We do not project case and complaint revenue in that number. And since our licensing numbers have stayed relatively consistent year over year, I am proposing to leave those revenues flat. The state regulatory fee is a charge by the state. We get charged $10 for each individual license that is issued or renewed to active status, as those licenses renew on a 2-year cycle. And we're charged $5 for each firm permit that renews, because those are 1-year license cycles or permit cycles. Moving down, so salaries, longevity, and employee benefits. These are based on our current team structure of a licensing staff of 4, myself and our investigator. There is a detailed breakdown in the materials provided that shows how we got to those numbers. I'll remind you, in October of 2022, the state pushed forth, they did a statewide survey to understand whether or not compensation was consistent with market compensation for state employees. And so there was we had a significant impact in FY23 and 24 from that. And so we'll continue to see those costs in future years. Travel, I have included a detailed breakdown of proposed travel costs. In attachment B to my materials, you'll see that we have budgeted for investigator travel, board staff travel for outreach events and other board business, as well as staff and board member attendance at NASBA events. This travel budget is fairly consistent with prior years. I'll pause there because that was a lot of information. Do you have questions? Does anyone have questions before I move on?
Mr. Chairman, I have a question, actually.
Yes, sir.
Just following on your being called to the principal's office.
Yes.
So if we are running a deficit and we're projecting to run a deficit and what we can control is licensing fees, how much latitude do we have to want to take destiny into our own hands, again, presuming that the costs are not going to fall in line with our projected revenues?
It's a great question, and actually I've spent part of the last probably week looking at different computations, permutations to possibly address that. And I've not talked with Jen about my calculations, but I do think that it would be important for me or Jen or possibly both of us to talk with Reed about that, because I think in general the governor's office would may prefer that we not increase fees. I can't state that emphatically, but I do think that we need to consult with the governor's, or at least Department of Commerce and Insurance, before we take any action. Having said that, Jen and I heard at least a couple of the representatives advocate for each board to review fees at each quarterly meeting, and we could do that, I guess. I'm not sure how productive that would be, but that's a great question, but I do think it would be prudent for us to talk with the Department of Commerce and Insurance before we take any formal action. But does that?
Mr. Chairman, I think the only thing I'd add here is, you know, when we look at the prior year actuals, when we have $1 million budget and we are basically within either $8,000 or $13,000 of our budgeted targets, I'm sitting there saying, great job on budgeting. I mean, this to me is not a crisis. I understand the tripwire that got tripped, and I'm thankful that you and Jan and Reed represented our board ably. But I'm not necessarily, I guess, you know, it looks like fiscal year 25 and 26 may be a more serious picture, and we'll have to deal with that. But I have to say, I'm not alarmed by what we encountered in 23 and 24.
It's a really good point, Kevin. I will say that, so for the Joint Ops Committee hearing, all the boards that were present were in the same situation as us. They had deficits for 2 years in a row. And Jen, I think I would be correct in this. In every case, at least for the boards under the healthcare, and then our board under Department of Commerce and Insurance, all of the deficits were caused primarily by the state's decision to increase compensation a couple years ago. So every committee or every board was under had the same issue. Is that fair?
I think that's fair to say. I mean, I can't speak for Department of Health, but for our boards, yes.
I have a general question, please. I should know this, but what do we charge for our relicensing?
So you mean our
The
renewal?
CPA license?
So an individual license renewal fee is 110, is that right?
110. Do we have any idea like what the pharmacists pay or the doctors pay or anybody else pays for their license each year?
I do not know.
I mean, that would be
That's a
good
good
information to know. I mean, $110, it's been that way a long time, I think.
Yeah, and you're correct, Robin. I did ask Lee to research that, and just based on the information we had at hand, I don't think you found the answer to that yet.
The last time the rule listing out the fees was amended was 2017. And then I'm going to look further to see what year the last amendment was for each subsection.
Yes, and Rob, you also mentioned during part of your conversation about per year, and remember that our licensees, individual licensees, renew every other year. So it's basically $55 per year, $110 every 2 years.
Right. That it just seems to be, I mean, I'm not a proponent of increased taxes or fees or anything, but golly, I mean, with the inflation we've had since 2017, I mean, what are we up? I mean, CPI is up, what, 20% maybe? Okay. I mean, it doesn't seem to comport that we're not charging enough. I hate to say that, but anyway, I understand how our Tennessee government works in terms of not raising taxes and that sort of thing, but it would seem to me that we're a little under budgeted on that.
So I'm concerned, as you are, about our expenditures exceeding our revenues. On the other hand, recall this hearing we attended, some of the legislators felt like that these reserves need to go away before boards start considering increases.
So that, I guess that's my other question. I've always wondered this. Is that like our retained earnings? Okay, so we don't have that money sitting in the bank anywhere, right, per se?
No, it is sitting in the bank.
In our bank, we have an account with $1.4 million.
Department of Commerce and Insurance has an account.
I believe
Correct.
I think it's pooled, like it's the division's
Yeah, I
money,
hated
but it
government
is-
accounting.
But it is, it
Does
is
anybody like
ours.
it? It's tough. But yeah, I understand I used to understand how that worked. Well, it just seems to me that we've had such good years over time, and I agree with you, so. But yeah, 187,000, that's not good. And we'll knock some of that out with our fees, and maybe if we could get on the wagon of charging for some of our costs, I mean, we might could recover $50,000 in that manner, I would think. Anyway, that's my idea. Thank you.
Jen, do you know the current fee for a firm renewal? It's a different amount, I think, or
$50? $50.
$50, and it's annually
Correct.
as opposed to biannually for a.
Correct. Okay. All right, there are a few other costs in here, nothing nearly as exciting as salaries and benefits and travel, but we do budget for communications and shipping, which represents that along with third-party professional and admin services, catches a lot of our mailing that we do. We send renewal notices to licensees and firms when they're up for renewal. Supplies and furniture, rentals and insurance and awards are all relatively minimal, but cover necessary costs for the board. Employee training covers some paid CPE for our investigator, as well as NASBA conference fees, TSCPA conference fee for myself in June. And then computer-related items simply covers exactly what it sounds like, computers for staff as those costs come up. And then state professional services, I believe, if I recall correctly, that covers department, yes, sorry, rent, IT support tickets, phone billing, administrative judges should we need them, and then printing services provided by the state. So that recaps all of our regular expenditures. As I'm sure you're all familiar, we also have cost backs that are charged to our board. Admin cost backs, legal cost backs, centralized complaints, and then customer service center. And those are all services, the department services that we use that we are charged for. So the bottom line, proposed FY26 budget, we're again proposing to be in a deficit of $187,485.
Questions?
Mr. Chairman, I would just like to go on record and point out that if you take just the total cost add backs, which is administration, legal investigations, centralized complaints, and customer service center, you could look there and say that just the cost of, the minimum cost to really do investigations per year, we're budgeting at $272,600 per year. Then if you come back up and look at the salaries of the people involved in looking at those investigations, it's even higher. And it just doesn't make sense for us to even consider passing along a fee to the people who are doing it right, to the licensees, when really it's the cost of investigating the people that are doing it wrong, that I would ask the administration to consider looking at those penalties, because those are the bad players. Those are the people that are doing it wrong. And when we do find those players, we should not have the ability to minimize that penalty where we're spending way in excess of what that penalty is to bring them to regulate the accountancy laws in Tennessee. And I think that points out even more strongly the conversation we had earlier with penalties and maybe the consideration of looking at those overall for all boards.
Okay. Other questions, comments?
Along those lines, Andy, do the other boards have an investigator like Duke? I mean, someone on staff that investigates, like the medical boards or something along those lines? Do we know?
I'm assigned to the Detection Services licensing program, and so when, in that program, I sometimes submit a request for investigation, and it goes to, I don't know if the right word is department, but there is a group within the department the Department of Commerce, that performs investigations. I don't think it's limited to detection services. I believe those investigators, it's a pool of investigators, and they perform investigations for multiple programs.
Do those departments get charged back for those fees?
I'm sorry, I do not know, but
Right, but I mean, Andy's point is excellent, is that we do spend a lot of money with compliance.
To
So-
touch on that, most boards utilize the department's investigation units. They have multiple investigators that tailor to certain boards, but it is one unit. So you guys are unique in that way, that you have your own investigator, which I think is great. But those boards are also charged for those investigations.
So is our allocation lower since we're not using it in the same capacity?
So-
I'm not sure.
Yeah, you'll see, we have zero in for the investigations chargebacks, and that's because of that, our cost is included in salaries up above.
Also, I think it's important just for this board to be aware of our staffing situation. I spoke at length with Wendy about this before she left the board, and she felt like that we have a great staff, and we're staffed at the appropriate levels. And so I asked Jen the same question independently of the information I had from Wendy, and I basically got the same answer, that we are staffed with great individuals who are dedicated to their jobs, and each staff person is needed and fulfills a specific role. Other questions or comments? Jen, you may or may not know the answer to this. I'm sorry I didn't ask in advance, and maybe our former chairs could help us with it, or legal. I am not sure that the budget needs to be approved today for submission to the board tomorrow. Does anyone recall?
I don't recall for sure, but I don't think that we did that in a committee.
I don't recall us
The
doing
board
it.
would act on it
Okay.
in total.
Good.
Yeah.
You okay with that?
I'm good with that, as long as there is a vote at some point
Okay.
tomorrow.
Good. Rob, did you have your hand? Okay, you're just, okay, good. Okay. At this time, we will move to our public comment period, and do we have any comments from the public?
No, sir, we don't.
No? Okay, good. Okay, so thanks, everyone, for being here. I failed to thank you at the start, but thanks again to our staff and our legal team. Our investigator, of course, is part of our staff, but we very much appreciate the work you do. Thank you, board members, for being here today, and we will convene for a board meeting at 8:30 a.m. tomorrow. Thank you.